Okay, question 1. So, first off, just start with a timeline. Okay, Larissa places advert in the paper. Memorise Partridge v Crittenden, invitation to treat. Also worth pointing out for that one, the exception to the rule, Carlisle versus Carbolic Smoke Company. Donald leaves note with and check with Tessa. Mention the postal rule on this bit in terms of it's not been put in the actual post or stamped or addressed. It's just a handwritten note. Also worth noting that if the cheque was worth something in any way whatsoever, it has been given to a minor. It's mentioned that she's a schoolgirl going on a school trip. So, no good. Emma posts letter. This only works with the postal rule in terms of acceptances, not offers. So that's what's worth mentioning there. If it was an acceptance, and this was a definite offer originally, then this would have been an acceptable acceptance, and Emma would have got the car before Gin. However, that's not the case. Gin's answer phone message, I've got that down as Brinkebon versus Stahl. So in that one, because the answer message was received outside of office hours, that means it's then considered received at 9 AM. However, there is some uncertainty in language in what was left on the answer machine message. Might even be worth mentioning, what's that case called? Stevenson Jackson Co versus McLean. So it's an inquiry rather than an actual counter offer or offer. But I would just go safely with that one. It's received at 9 AM. The counter offer, Hyde versus Wrench, is when Gin then phones at 9:30. And then it's worth mentioning with Emma in the postal dispute that it wouldn't matter because it's a offer, not an acceptance. But also, if it was an acceptance, it doesn't matter, it's when it arrives, not when it's posted, not when it arrives. And then Larissa receiving the others there. None of them have a clear claim. Only Gin has the clear claim, and he cancels out his counter offer with that one there. It's worth mentioning Entourage versus Farmyard East when it comes to them speaking on the telephone. So, cases that I've got here. Carlisle versus Carbolic Smoke Company. Partridge versus Crittenden. Hyde versus Wrench. Brinkebon versus Staghad Stahl. Entourage Limited versus Miles Far East Corporation. Stevenson Jackson Co. versus McLean. Adams v Linsell. Dickinson v Dodd.
It's past.
Yeah?
Go.
Question 1 continued. Offer and acceptance. An offer is an expression of willingness to contract on specified terms. Party who makes an offer, offerer. Party whom the offer is addressed, offeree. Originally, courts used to look at whether there had been a meeting of the minds, consensus ad ideum. Now there is an objective test of intention. Invitation to treat can be accepted or rejected. Invitation to a treat equals an then preceded by an offer, then preceded by an acceptance. Means that the contract is formed. Acceptance is final and unqualified assent to the terms of an offer. Counter offers destroy previous offers. Inquiries do not destroy offers. Postal rule applies to acceptance only. Acceptance by post must have been requested by the offerer. Post must be properly stamped and addressed. Must be posted. Handing to the postman will not work. Must not be excluded in the offer. Must not manifestly be inconvenient. Kill. Carlisle versus Carbolic Smoke Company. The reason I have chosen this is to apply it to Larissa's advertisement because it does not fit into this category. It's not a unilateral contract and doesn't apply to that. Partridge versus Crittenden. Larissa's advertisement fits this description. It's an invitation to a treat. Hyde versus Wrench. I'm going to imply to Gin's final phone call with Larissa. the answer phone message being the original offer. Brinkerbon versus Stalag Stal. Gin's answer phone message is the original offer to Larissa, and the reason why that's to do with telex sent outside of office hours. It's deemed to be received once the office reopens, so that would be 9 a.m. And Torres Limited versus Miles Far East Corporation. I'm going to apply to Larissa receiving Gin's phone call at 9:30 a.m. and accepting his counter offer. Stevenson versus Jackson Co. versus McLean. An inquiry is not a counter offer, all about clear, definite language. Might mention that one in relation to Gin's answer phone message because the language seems a little bit more like an inquiry, but then move on, small sentence. Adams v Linsell. I'm going to talk about the postal rule, and I'm going to apply that to both Emma's letter and also to Donald's note. Dickinson versus Dodds. Third party can revoke offer. I may try and apply this in some way to Tessa, maybe, and also she's a minor, so discounted anyway. Thank you. Right.
Go.
Question 2. Now this is the one I least like out of the 4 questions. So question 2. Apparently there is no general doctrine of mistake. Contract may be void at common law. 3 categories of mistake: common, mutual and unilateral. Common means both parties make the same mistake. Mutual means mistake on different things. And unilateral is where one party is fooling the other. The common mistake: res extincta, void at common law and equity. Common mistake: res sua, void at common law and equity. Common mistake: false and fundamental assumption, contract valid at common law or equity. There may be rescission, rectification or specific performance. Mistake as to the quality of a thing must be a mistake of both parties as to the existence of some quality which makes a thing without the quality essentially different from that is what it's believed to be. Risk of mistake test. He who fails must pay the price. Meeting of the minds. Consensus ad idem. Doctrine of mistake is very, very rarely used. Common law much narrower than common law and equity combined. Common mistake. Both parties make the same mistake. The only remedy for common mistake at common law is void ab initio, so void at the outset. Res extincta, subject matter does not exist. Most common mistake in common law. Res sua, can't buy something you already own. Think Cooper versus Phibbs. False and fundamental assumption. Could make a contract void at common law as a false and fundamental assumption as to the quality and substance of the subject matter, and it must be sufficiently fundamentally false assumption. There can be types of impossibility: physical, commercial, legal. Common mistake has a very limited scope. In common law and equity contracts, voidable rather than void can lead to a more just outcome. Equitable remedies. Equity, rescission, specific performance, rectification. With rescission, contract voidable rather than void. Valid contract up until the court declares it. Specific performance, where monetary damages will not suffice. Order party to do something. Or rectification, mending the contract itself. Pause. There we go. The cases I've chosen and why. Couture versus Hasty, 1856. This is an example of res extincta, the usual form of common mistake. The corn perished on the voyage, sold at Tunis, purchaser did not have to pay for the goods. Contract void for common mistake. So it's common from the minute the contract started, void ab initio. Cooper versus Phibbs, 1867. Res sua, cannot buy something you already legally own. Impossible. This is the nephew and fishery lease. Equity, not common law used. Legal impossibility, voidable in equity. Shade Brothers Limited versus Oshner, 1857. Physical impossibility. This is about a size of crop, land not big enough to provide that quantity. Contract void at common mistake, and instead of using the doctrine of mistake, they preferred to use the Indian contract law of 1872. Griffiths versus Brymer is commercial impossibility. Hired room for king's coronation. King has to have operation. void for common mistake. Taylor versus Caldwell, 1863, res extincta. Contract depends on the continued existence of a thing. Contract void. Associated Japanese Bank Limited versus Credit du Nord SA, 1988, res extincta. This has widened the scope because the 4 machines leased back to a firm, they were still using the machines, but it was a means of raising funds. So this one was actually decided on the fact that they'd had the funds. So that worked quite well in that respect. And it was a valid contract. The focus was all on raising capital. Grist versus Bailey, 1967, common mistake in equity. Selling a property for $850, worth $2,250. Contract rescinded with option to buy for $2,250. So in that one, the contract was rescinded. Soul versus Butcher, 1950, voidable in equity. Rent case charged $250. There was a rent cap in place of $140. Lease rescinded, and so there again, the contract is rescinded. A remedy has been found in equity. Leaf versus International Galleries, 1950, substance and quality. Salisbury Cathedral, no guarantee to the artist constable. Sufficiently fundamental, not void on grounds of substance and quality. Bell versus Lever Brothers Limited, 1932. Mistake as to quality, false and fundamental. Golden handshake made redundant, but had committed acts that amounted to gross misconduct during employment. Contract not void. McRae versus Commonwealth Disposals Commission, 1950. Equity was used. What worked in Courtier would not have worked out here. That's why the remedy was found in equity. Oscar Chess Limited versus Williams, buyer beware. So basically the law is more on that side. They don't want to be interfering with business in any way. And that's with the Morris car that was actually 10 years older than they thought it was. And the contract was found not void at common mistake. But had it been submitted earlier, there may have been a case for common mistake in equity. Great Peace Shipping Limited versus Savalis Salvage International, not void for common mistake in equity. Defendant liable for the cancellation charges, ships far away from each other, and this in an attempt to limit the scope for common mistake in equity to stop it running away with itself.
1, go.
Question 3. So, with Bean, his crops have been blighted, which is material damage to property. He's lost the enjoyment of his garden, which is aesthetic enjoyment, but that on its own wouldn't have stood just as a claim on its own, so it might be worth mentioning that one first. The building works next door have been going on 12 months, already 7 days a week, and a further 6 months to go. That seems a bit much. Boggis does not need to be owner of the land to be liable for the hazard activity, just to bear in mind. Are there contractors involved? Even so, Boggis would be liable for hazardous activities undertaken. Boggis, his defences could be either public utility, based on the fact that it's a wind turbine and that's a green fuel, planning permission, but however, we'd only mention planning permission to say it could literally go in either way. Boggis may have a claim against Amplify Accountants for pure economic loss, negligent misstatement. Look at Headley Burn, Candler, Crane and Christmas and the South Australia case. With James, he has no interest in the land and not a valid claim for private nuisance. Consider HRA Article 8, right to family life. Perhaps the law may change to be in keeping. The eggshell rule, negligence, and I've put about Bonington Castings Limited versus Wardlaw, material contribution where but-for tests can't be used, e.g. dust. And also McGee versus National Coal Board, started in Wardlaw and developed within this case for material contribution. That's that.
Go.
Hunter versus Canary Wharf, 1997. Threefold division: encroachment, physical damage, and interference with use and enjoyment of land as private nuisance. I would use this for Bean versus Boggis, private nuisance. St Helens Smelting Co. versus Tipping, about air pollution, damaged trees and shrubs, material injury to property, consequential and economic loss. Bean versus Boggis, private nuisance. Cambridge Water Co. v Eastern Counties Leathers plc. This is just to say that what happened must be reasonably foreseeable by the defendant. Bean versus Boggess, private nuisance. Kennaway versus Thompson, the defendant has substantially exceeded the normal give and take of life. Bean versus Boggess, private nuisance. Gillingham Borough Council versus Medway Co Limited, public nuisance claim failed, tried to use planning permission. It was deemed to be an okay change in the area. So with this, they tried to use planning permission and the claim was not upheld. But with Wheeler versus JJ Saunders Limited 1996, nuisance claim was upheld despite having planning permission. So it goes to show with these two cases, having planning permission means it can go either way, it doesn't matter. The only real defence that Boggess has is public utility. Now, for James, we need to look at Donahue versus Stevenson, 1932, the neighbour principle, reasonably foreseeable harm likely to injure a neighbour. Also, mention that is less like that is where it started, but now what would be used, and especially in a novel situation such as this, would be Caparo Industries plc versus Dickman, 1990, three-stage test, proximity and fairness, duty of care established. And then it's worth looking at Bonington Castings versus Wardlaw, reasons already explained. McGee versus National Coal Board. And then I would be moving on to can't make a claim as private nuisance. So I've done the negligence bit and said what I thought about that. Or I might do this the other way around. And then I'll say the private nuisance bit wouldn't be able to have a claim because there's no interest in the land. And then I'd also cite the McKenna versus British Aluminium Limited. 30 children from a number of families suffered physical and mental harm. And then I would go into the Human Rights Act, Article 8, Right to Family Life. Then for Boggess versus Amplify Accountants, I'd do Candler versus Crane Christmas & Co. Pure economic loss, negligent misstatement, valuation of the company. South Australia case, where pure economic loss, negligent misstatement again. Claimant receives the difference between the negligent overvaluation and the actual value at the date it was valued. Headley-Byrne versus Keller, negligent misstatement, assumption of responsibility to establish a duty of care. Alright, with private nuisance, the claimant has to have interest in land, you must select the correct defendant, material interference or harm, reasonably foreseeable, unreasonable use of neighbouring land, any defences. So claimant, Bean, perfect. Defendant, might be worth putting a sentence wondering whether it's Boggess or contractors. We'll go with Boggess. Material harm or interference, so can't use the garden, and also blighted crops. Reasonably foreseeable, it says it's a large quantity of dust, so they must be aware of dust. Use of neighbouring land, 7 days a week, and continuing for another 6 months. The defences, public interest, greener fuel, or public interest or utility, that would be the greener fuel. And then also the planning permission, say it's going to go either 50-50 on that.
Okay.
Right, don't like question 4, but we'll go anyway. There is no single common denominator, even in cases of economic loss, by which liability may be determined. It's all about determining who is liable and duty of care. With all the reading that's led us to, these are the things that were thrown up in the reading. So, question 4. Assumption of responsibility derives from Headley-Byrne to establish duty of care for a negligent misstatement. It's a restrictive area of law on policy grounds to stop floodgates of claims opening with unlimited liability indeterminable. Main alternative to assumption of responsibility is Caparo. Regardless of contractual or fiduciary relationship and despite consideration, assumption of responsibility can be established. With the assumption of responsibility, relationship is special, which creates proximity to overcome policy objections and justify a duty of care being imposed. With the Headley-Byrne case, using the voluntary assumption of responsibility, it was easy to justify this method to establish a duty of care. It was a credit agency, it was reasonable for them to have been able to rely on the information given, and it fits neatly. This led to negligently provided services, Spring versus Guardian Assurance, job reference negligently provided, direct relationship between the parties. Now, this side of the law continued to develop and led to doubts and uncertainty when it came to Henderson v Merit Syndicates, and was less reliant and more indirect in that information there. Voluntary assumption appears to require directness or at least sufficient knowledge. Lord Musthill, dissenting judge in White v Jones, felt a mutuality should have existed from the receiver of the services and he had already died. Lord Griffiths felt assuming responsibility should be towards the person relying on the advice and on all the service, like in Smith v Eric S. Bush. Applying of voluntary responsibilities does not work for Smith or White, so the Capare test was applied. Lord Walker described the Capare test as a blunt set of tools. However, this vagueness has some merit or scope because it allows judges to look at all the circumstances. Conclusion: use both tests to find a fair, just and reasonable outcome. Pause. Let's go. Hedley-Byrne versus Heller, 1964. Assumption of responsibility establishing duty of care for negligent misstatements. Credit reference. Reasonable for claimant to have relied on appropriate circumstances. Neatly fits for this case without indeterminate liability. Exclusionary rule prior to this. You could not claim for pure economic loss then. Spring versus Guardian Assurance. Hedley led to this case. Negligently provided services. Job reference prepared negligently. Extension permitted due to direct relationship of the parties. Extended Hedley-Byrne liability. Henderson v Merit Syndicates, 1995. This is where doubts and uncertainty were expressed. A was contracted to B to do work for C. Knowledge and reliance. This case had less reliance and more indirect relationship. Extended Hedley-Byrne liability, the doubts. White v Jones, 1995. Daughter's father's will. Question of if it still applies when a person is dead. Mutuality must exist. Lord Musthill links to Lord Griffiths in Smith versus Eric S. Bush. Lord Griffiths felt assuming responsibility towards the person who is acting on the advice. Capare test used as voluntary responsibility, not just. Customs and Excise Commissioners versus Barclays Bank plc, 2007. Lord Walker called the Capare test a blunt set of tools. Vagueness has some merit. Question of whether voluntary assumption only happens voluntarily, and that will be about voluntary assumption. Capare Industries versus Dickman, used as either sole determinant or to cross-check voluntary assumption rule. Threefold test, establishing duty of care. Cattle v Stockton Waterworks Company shows court's cautious approach to awarding damages for pure economic loss. There was a tunnel under the road and it flooded. This shows how the law was exclusionary before. Murphy v Brentwood DC, confirmed relational loss rule. Economic losses are irrecoverable. Injury to the property of a third party with no interest in land. Limited extent claims would succeed. Exclusionary rule. And then Williams v Natural Life Health Foods, 1998. Claim not upheld. Franchisee tried to sue company who went bankrupt. The law is becoming clearer, moving forward, more restrictive. So pure economic loss usually fares badly. Major exception is negligent misstatement, voluntary assumption of responsibility leading to extended Hedley-Byrne liability to extend services. All about establishing a duty of care. Capare three-stage test is either sole determinant or to cross-check. Can voluntary assumption only arise if voluntarily? That's CEC versus Barclays Bank. Cautious approach prior to all of this. Cattle v Stockton Waterworks. Exclusionary rule restricting, and limited extent claims can go. Murphy versus Brentwood DC. Now, with regard to the exclusionary rule, might be worth stealing this conclusion from the units. Hartshorne agrees with Steele that there is no general exclusionary rule in relationship to pure economic loss. Dividing it into core categories could be sensible moving forward.